Mr. Collins.
Thank you, Mr. Chairman. Again, I think this is interesting to see the results and also the discussion of ICANN, because the transition of ICANN and the termination of the INA contract are the two main issues. First, should we terminate that contract? The second, are we ready at this moment to terminate that contract? The committee a while back last year actually held explored the first question in previous hearings, so my question in my line of thought is going to focus on the second. But based on the evidence I've seen, and I want to ask unanimous consent, Mr. Chairman, to enter into the record, there's a laundry list of recent ICANN failures that should really cause—
Without objection, the laundry list is placed in the record.
Thank you. And my wife's part is took out, so it's just there. It's just mine. I believe ICANN is engaged in a pattern of behavior that indicates their lack of commitment to follow through on their contractual obligations that exist today. A multi-stakeholder model is effective when the community agreements are respected and enforced, and when the administrator, ICANN, takes seriously their responsibilities to live up to the commitments they've made. I'm concerned about the lack of accountability, transparency I've observed on the part of ICANN. In fact, it's probably like an old commercial that you've seen on TV, the Cheez-It commercial. I just don't think they're mature enough ready to be baked into a system. So I think into a cracker. This is a part that just bothers me because there just doesn't seem to be the understanding of the concern that most of us have and has been discussed here today. So a couple of questions I want to start with. Ms. Stark, the first is, in 2011, you told Congress that the first round of new GTLDs would cost the business community conservatively $12 million in defensive registration fees. Some claim that that number was an overstatement. Was it?
No, I would actually say that for some companies that are really interested in protecting a whole host of brands, the numbers could be even worse. In 2011, I had noted that a large corporation might look to register maybe 300 defensive names in what was then anticipated to be about 400 spaces. And we averaged that out at just a cost of $100 a name, right? That's how we got to that $12 million. Well, I think the costs today remain unknown. We haven't even delegated maybe half of the names into the space now, but you're not looking at 400 names any longer. You're looking at over 1,300 new spaces. And from our calculations, the average Sunrise registration in the spaces that have gone forward is more like in the $300, $350 range when you average it across all those spaces. So that, again, is triple what we were talking about in 2011. And then if you look at this .sucks example that we've been discussing throughout today, you're talking about for a single mark, it costing $2,499 a year. And like I said, if the brand owners register all the marks that they've put into that clearinghouse, that's a cost to business of $90 million a year. It's extraordinary.
It is. I want to stay right here with just one more question with you, and it's a concern that rogue website operators are increasingly engaging in the domain hopping, switching from one TLD to another to maintain their brand. For example, there are several sites that trade on the Pirate Bay's name, even though the site's operator have been convicted of criminal copyright infringement. Some of these sites are existing TLDs, thepiratebay.com, thepiratebay.com, .org, and others with new GTLDs. Do you think it's fair that rights owners or law enforcement take action against one domain only to have the same problem arise, basically trading on the same name with a different TLD?
So I think that that is an extraordinary challenge for companies like mine, and I very much appreciate you raising it. We are always looking for ways in which to more efficiently kind of address these problems without having to tackle people as they hop around the world and hop around the internet from name to name to name. I don't know that I have a solution to that, but I do think that it really creates a resource challenge when what we are trying to do is get out legitimate content to people and sort of spur innovation and productivity in that same internet world, and what they are trying to do is simply steal it.
Well, and I think this is something that's very important, because you're actually, it's sort of the tree here. We're following, this out, and I think that's, you can do it in other cases, criminal cases, you do it in others, but especially in this kind of case where you've had this blatant kind of topping around that is just against, and so I appreciate that. Mr. Medlitz, how important is it for accuracy and integrity of the WHOIS database to the function of accountability and the rule of law to the online ecosystem? And also, who or how do these issues intersect with the public interest commitment, the registrar accreditation agreement, and the other ICANN standards of online accountability?
Thank you for that question. Who is extremely important. It's a key element of accountability and transparency to know who you're dealing with online. ICANN was given stewardship of this database 15 years ago, back in the monopoly days, right after the monopoly days that the chairman was referring to, and it has not fared well during that period. It's less accessible, and it's certainly less accurate, apparently less accurate now than it was then. And we have a problem now that 20% of the registrations in the GTLDs are registered to proxy services. So it doesn't really, it just puts a barrier between you and finding out who you're dealing with online. And I think your previous question to Ms. Stark was very well put, and we have two problems there. One is we have some legacy registries, such as .org. So even after oldpiratebay.org was brought to their attention, and Pirate Bay has been the subject of orders in many countries, the people who ran it have gone to jail in Sweden for copyright infringement. Even after that, .org would not take any action, the operators of that registry. But then we also have a problem with the country code top-level domains, the two-letter domains, right, that ICANN has no control over. And some of them have been quite cooperative, but some have not. So this is another frontier that we still need to deal with in this effort to try to enforce our copyrights.
Well, and I think that's something the chairman and I have worked on a great deal, and because if we continue this hopping around, we continue this non-transparency and this non-accountability, then we're simply setting ways that are affecting business. It is affecting really that ingenuity, that spirit that we're trying to incorporate, and especially when it comes to just blatant stealing and copyright infringement, which is, let's just call it what it is. So I appreciate that. I know Amazon you've had an amazing story with ICANN and the problems there, and could go into that. So I wanted to recognize that fact. I've seen that. And for all of us here, this is just, again, I think it's just an example that there's the problems here and it's not ready. And I think that's the thing we go back to. And with that, Mr. Chairman, I yield back.